Hi everyone, welcome to my video on Rylands versus Fletcher with a very special guest star, my dog Lady. Lady is going to be my glamorous assistant and help me by my arm going numb, but she hates being on the floor, so we're going to have a bit of a cuddle. So I wanted to go through Rylands versus Fletcher. Oh, you're interested now. Have a bit of a sniff. So we're going to have a look at Rylands versus Fletcher because it's an area of law that sometimes students find a bit tough, which I can never quite understand because actually it's quite straightforward. So my job in this video is to try and show you how simple it is, and that really puts you at an advantage in the exam because a lot of students aren't very confident with Rylands versus Fletcher, so they probably wouldn't answer a question on it, which makes it a really good alternative to something like negligence, which is actually quite big and probably very, very popular. So it allows the opportunity for you to try and have a go at something that other students probably won't feel so good with. Are we okay? No? Oh, for once I think we're wanting to get down. So let's put it to bed and then we will crack on. There you go. Right. Okay, so how do you crack Rylands versus Fletcher? How do you get the best marks in the exam? So what I'm going to focus on is the AO1, which is worth 10 marks. And what I've tried to do is to break that AO1 down into some nice, easy keywords. Hopefully, if you learn these key phrases, keywords, then you'll have a nice easy structure for your AO1. Then all you need to do, if it's a scenario question, is then apply each of the elements. And if it's an essay question, critique each of the elements. So hopefully it'll make it nice and straightforward. So I'm going to kind of leave the cases really to you. That's because different teachers, different textbooks have different cases in them. So you can really personalise it. I might refer to a couple, but what I would suggest is that you go through and write this down with me and then add in your own cases afterwards for your own revision to kind of flesh it out. So the thing with Rylands versus Fletcher, and I think this is the thing people struggle with, is it isn't particularly difficult. It's just a bit dull. It doesn't seem very applicable to the real world anymore. It's very old, comes from 1868, so some of the language is probably not what we would use. None of those things add together to make it an unpopular topic, whereas actually it's quite small, it's quite nice for revision, and because you can break it down into a nice easy checklist, it makes it easy to apply. So actually, for smart students, it's a bit of a win to revise. So let's go through and talk about it. So a bit of context, remember, is it Rylands versus Fletcher is an area of law that was named after the case itself. So it was a case back in 1868 where a mill owner had hired contractors to build a dam to power their mill, water power. This was built and there was no negligence. It collapsed and it flooded the neighbouring mine and it killed hundreds of people. It was a really, really big disaster, very, very sad event. So the owners of the mine tried to sue the owners of the mill. Now, there was no negligence. The mill owners hadn't done anything wrong. They'd been very responsible and hired good contractors. This isn't a nuisance because it has to be more than a sort of one-off. It's not trespass because the mill owners didn't put the water there on purpose. It's not occupiers' liability because they weren't on the mill owner's land. Basically, there was nothing in tort law which would give a fair outcome. So it was looking like the judges were going to have to turn around in the case and say, sorry, you get nothing. You get nothing for all of those hundreds of deaths. You get nothing for the huge damage to your property. And that just didn't seem very just and very fair. And that's something we look at in the nature of law module. The law should be doing things that are fair. So what the judges decided to do is they kind of created a rule and said that if a defendant brings and accumulates something on their land, which is a non-natural use of land, and that thing's likely to cause mischief if it escapes, if it does escape, then there should be a claim. Now, at the time in the House of Lords, I don't think the judges actually realised what they were doing, and it's reflected in the fact that in the law reports, they didn't even name the third judge. I don't think they kind of realised that they were creating a whole new tort back then. But what it did was it kind of opened up a new area of law, and of course, justice and fairness is that if one person is allowed to claim under it, so should other people. So with that kind of statement, with that judgment, they created a new area of law, but they didn't clarify anything. They didn't discuss what they meant by those terms because they probably didn't realise they had to. So after that, judges, academics, lawyers have had to try and interpret what some of these terms mean to apply them fairly in the future. That means you have to understand what the terms mean. Now, if the judges have faced a lot of disagreement and confusion, how do you think we're going to feel? But again, I think there are some fairly straightforward points that we need to be aware of. So first things first, before we get into that sort of definition from the House of Lords, is to talk about C and D, the claimant and defendant. So who are the parties that you would have to talk about? So the first thing is that C, the claimant, must have a proprietary interest. Now that's because it's an offshoot of nuisance law, and they have to have a proprietary interest. So what that means is you have to own or rent the land. That's because it has to cause damage to your land, so you can't sue if it's not your land. Makes sense. Now the defendant, it's basically just about control. They control the land that the thing escaped from, or they control the thing that escaped. So it makes sense that you sue the mill owner, you know, because it was their dam that burst. So get those really easy out the way first. Make it very, very clear. Right, let's actually now look at the old definition. The first thing they talk about is you have to bring and accumulate something to the property. Bring obviously means it wasn't there to start with, you've brought it there. And accumulate means you're keeping it. It's not just kind of passing through. So for example, water always causes some confusion here for students. So often appears in exam scenarios. So for example, rainwater that gathers in a puddle is not brought and accumulated. We haven't done anything to bring and keep that on the land. However, if you think of a reservoir, like in Rylands versus Fletcher, we've kind of brought that water together by digging the hole, by digging the reservoir, and then we've accumulated it. We're actually keeping it there. The same sort of thing applies to kind of like an ornamental pond. You've dug the pond out, you're trying to keep the water there, or a kitchen sink, a tap. By turning the tap, you bring the water to you, and I suppose you're kind of keeping it in the sink. This is why it has to be kind of something that's not naturally there. So things like rainwater, rocks, weeds, flowers, trees, they don't come under this because they haven't been brought and accumulated. So for example, if your neighbour's tree falls over and it falls into your back garden, damages the fence, damages your property, that's not a Rylands claim because they didn't bring the tree on their land and accumulate it there. So this is why you have to be very, very careful with the word natural. So what we're talking about here is, I mean sort of Mother Nature. Did Mother Nature put it there, or did the defendant? In a reservoir, like Mother Nature didn't create a reservoir, the defendant did. But if you think of like just rocks lying there in the ground, or like sort of thistles grown out of the ground, like in Giles versus Walker, you haven't brought and accumulated them. So that's got to be the first thing. And the main reason behind that is because if you bear in mind the key aim of Rylands versus Fletcher is to stop the defendant from unfairly profiting from industrial activity. So if you bring something dangerous, poisonous to the land, you have to take responsibility if it escapes. So in Rylands versus Fletcher, by bringing that reservoir to their land for industrial purposes to power their mill, they have to take responsibility if something goes wrong and it escapes and it floods. So it has to be something that you have purposefully brought to the land. So bring and accumulate essentially means that you store something that's not already there. It has to be for your own benefit. Okay, so what that doesn't include is kind of public services. So in Dunn versus the Northwest Gas Board, that was gas that had been accumulated for public use. You couldn't sue because they haven't brought it for their own benefit. However, if it was like a sort of private electricity company, they would be responsible because it is for their own benefit. They are making a profit. But if it's kind of a public or nationalised service, then it's not. Right, key one, difficult one is non-natural. It must be a non-natural use of land. And the courts have really struggled with this term because back in 1868, by unnatural, we meant kind of strange, unusual, spooky. I always imagine witches and things like that. Oh, that's non-natural. We probably now think of it as man-made, but that's not the case. So non-natural was more recently clarified in the case of Transco and Cambridge Water, and a better word is extraordinary. Now, this is going to very much depend on the time, on the place. If something is domestic, so it's for the use of houses, then it's going to be normally seen as natural and therefore it doesn't come under it. So for example, in Sochaki versus Saz, it was a fireplace, which is something a lot of people have. That wouldn't be a non-natural use of land and therefore it can't be a claim. In Rickards versus Lothian, it was a sink. Now a sink is a natural, ordinary use of land nowadays. We all have sinks. However, in Musgrove versus Pandelis, it was a car in a garage. Now, this was 1919. Very few people had cars. And it was even more strange to store them indoors. So that was non-natural. Nowadays, if something happened in my car in the garage, that wouldn't be seen as a non-natural use of land. This is often going to be a sticking point. And this is often a reason why Rylands fails. If you use something in a normal, ordinary way, in a normal, ordinary place, it's probably going to be natural and therefore you cannot sue about it. This was seen in Cambridge Water. The fact is that they were storing large amount of chemicals was seen as a non-natural use of land, even though it was in kind of an industrial estate and it was quite normal for a leather tannery to have chemicals. The court said most people don't have that. So large quantities is a good indication of something being non-natural. So for example, a lot of us have boxes of hair dye in the house. Hair dye is a chemical, but that's quite a natural thing to do. But we probably don't have vats and kegs of it in the garden. If you did, then that would probably be a non-natural use of land. The next thing is it has to cause mischief if it escapes. Now, this is a very ye olde word that we probably don't use very much anymore. And this just means damage. Now, the thing itself doesn't have to be dangerous. It just has to be dangerous if it escapes. And the case of Schiffman is a really good example of this. And this involved a flagpole that fell off and damaged someone's property. Now, a flagpole is not inherently dangerous. We're not all walking around with fear of flagpoles. They're not seen as a kind of dangerous item, but of course, if they fall off, they're going to cause damage. So it's likely to cause mischief if it escapes. Now, fire, lots of people have fireplaces. It's probably not seen as an inherently scary thing, but of course it's going to cause damage if it escapes. Water's not inherently dangerous. We don't see our taps as dangerous, but they'll cause damage if they escape. So this one is actually probably quite easy. Would it be likely to cause damage? So I mentioned hair dye before, for example. Hair dye is not particularly scary or dangerous, but of course if it leaked, it would probably cause damage because its whole point is to change the appearance of things. So that brings us on to the idea of escape. And this is the idea of movement. All right, so it has to go from the defendant's land to the claimant's land. There has to be an element of escape. So if, for example, in Reed versus Lyons, the weapons inspector was injured when a shell she was inspecting blew up. Thing is though, it blew up on her in the defendant's factory. It didn't move, it didn't leave. Therefore, it wasn't a Rylands versus Fletcher claim. So if you're hurt on someone's property, that's probably occupier's liability. There has to be movement. It has to go from one property to the next. Now, this caused a lot of confusion when it comes to fire. And in the recent case of Gore versus Stannard in 2012, as recent as 2012, the court made very clear that the thing that is stored has to be the same throughout. So the thing has to be non-natural, that is stored on the land, and it has to escape. The thing itself must escape. Now, in Gore versus Stannard, it was a pile of tyres. Now, they brought and accumulated the tyres. Are tyres a non-natural use of land? Well, they were storing lots and lots of them. Are tyres inherently dangerous? Could they cause mischief if they escaped? Probably not. Now, the tyres set on fire and the fire spread to the neighbouring property and caused damage. Thing is, it's the fire that escaped, not the tyres. Now, fire is clearly dangerous, but they didn't bring and accumulate the fire there for their own benefit. It was an accidental fire that started. So the claim failed. It must be the same thing throughout. Now, if one of those tyres that were on fire escaped, so that, you know, a flaming tyre rolled down the hill and rolled into my garden fence and set my house on fire, that would be different. That probably would work. Now, this is why older cases would probably fail now. So LMS versus styrene is similar in 2005. The polystyrene caught fire. The fire spread to the neighbouring property. That would fail now because the polystyrene didn't escape. And the polystyrene is what was brought and accumulated. The fire wasn't. Now in Sachaki versus Saz, the fire was accumulated because it was a fireplace. We were actually wanting the fire. We're bringing it there for our own benefit to keep warm. But it's not non-natural because a lot of us have fireplaces. So there was no claim. So you've got to be really careful to pick on the same thing throughout the whole question. So tyres, were they brought and accumulated? Are they there for the defendant's benefit to sell, for example? Is having tyres non-natural? How many are we looking at? Where are they? Are tyres likely to cause mischief? Did the tyres escape? So the examiner loves putting fire in scenarios because you've got to be really, really careful with fire. Did the actual thing that the defendant brought to their property then leave the property? Because they should make sure it doesn't leave the property. Right, it has to cause damage, as we've mentioned. So it has to cause damage to the claimant. So there's a few things here. So first off, the damage has to be foreseeable. Not necessarily exactly how it's going to happen, but is it foreseeable that if that escapes, that would get damaged? And finally, in terms of damage, it can only be damage to property. That's because it's a land tort. So what that means is there is no claims for personal injury. And that's the main one. So in Hill versus Jennings, when the fairground ride came apart, it hurt someone. That wouldn't be a claim now because it's been clarified now. It's land. It has to have a proprietary interest in it. So if someone's hurt, that's a separate claim, perhaps in negligence. It has to be damage to property. And finally, there has to be no defence. So the defences that you could have, and there is a number of them. So even if you manage to make it down this list, the defendant's probably got a defence they can use. So we've got active stranger. In other words, is there another third party that came along and caused the escape that we can pin the blame on them? Is there an act of nature, an act of God, as the old law called it? Those are the two main ones. We've also got things like valenti. Did you consent to that thing being there? Those are the two main ones. So act of a stranger, it has to be an unforeseeable third party. And in act of nature, it's got to be an unforeseeable, terrible weather event. Notice the link between the two. It's got to be unforeseeable. In other words, the defendant couldn't have done anything about it. They couldn't have protected. They had no idea it was going to happen. So in Nichols versus Marsden, for example, it was the worst storm in recorded human history. How do you prepare for that? And how do you kind of stop that escaping is the question. So Rylands is actually quite straightforward if you stick to that structure. So my advice to you is to try and learn these 8 key terms, learn them off the top of your head, and that should give you a structure to go through with your AO1, do that first, explain these terms, talk about these cases, and then apply it to a scenario. So hopefully that makes it a bit more straightforward. I would really, really recommend that you stick with it for revision. It's not a very popular topic choice, so it really gives you an edge to get out in front of other candidates. If you've got any questions, just feel free to email me or the rest of the team law. Thanks.